Well, there's been outrage over the last 36 hours or so about a ruling in the Eastern Cape in which the acting Judge Thembeka Ngucaitobi has overturned a finding by a magistrate that a man was guilty of rape. Now, I must just tell you, this is a difficult conversation to have. If you have children in the room with you, you may want to just mute the sound for a few moments. Just keep the screen on, mute the sound, grab the remote and do that. So here's what happened. In essence, the man was first convicted of rape when he said he did know that the woman had not agreed to penetrative intercourse because she had agreed to oral sex and watched him get undressed and knew that he was in a physical state in which he was ready to have intercourse. The regional court found that the regional magistrate found that he was guilty of rape. The High Court says he was not guilty of rape. This is despite the fact the woman had said at the beginning of the encounter that she wanted to remain a virgin. Glennie is the founder of the Tears Foundation. Mara, good afternoon to you. This is a complex case. The details are important and at the same time perhaps difficult to talk about. But in the end, let me put it to you, in the end perhaps the most important thing is that the woman said at the beginning of the encounter that she did not want to have penetrative intercourse. For you, is that the most important aspect of this?
Yes, I think it's an extremely important aspect. I think that in a country plagued by gender-based violence, the fact that a judge would rule that consent to one act is consent for all acts will forever blur the terrain of abuse. The fact that this judgment has happened again on appeal will discourage people from coming forward. One of our biggest problems is that less than 10% of rapes in our country are reported.
The issue of consent is crucial to this, and I mean, we've seen this in other cases. So, and I make this comment very generally, but consent is often not given explicitly, it's given implicitly. And I suppose the issue might be around whether the behavior before the penetrative sex meant that permission had been given implicitly. And I think society is changing on this. I think society is beginning to demand explicit consent.
Yes, it is, and I think that there are other hidden aspects to this that one doesn't see, because if you share a marital bed with your husband, is the fact that you sleep in the bed giving him consent? Because we still have rape within marriages. So our view is that consent for one sexual act at one time does not imply ongoing consent. And consent is what it's all about. It's your body, your choice. And so I do believe that this will be appealed, and I also think that we need to take a close look at our laws, because in this country, on the books, we have some of the best laws to prevent sexual crimes in the world, and yet we have so few convictions. So we will have to pay close attention to this.
Well, I mean, I remember it took, I think, 8 years for the current sexual offences bill to finally become law. Now, we'll wait to see what happens. I don't know if there will be an appeal. I've seen some commentary on our channel earlier today which suggests there may not be, because the NPA would have to appeal this case. And it might just be that the judge had no other choice but to follow the law. So we're back to this, the law failing the women of this country again.
Indeed. It's an abuse of power, and the law is failing women. And that is why our rape and abuse continues to escalate in the country. And it is a very, very difficult situation. But let's remember that we are not living in isolation. We recently had someone in America, a person who was in everybody's TV every week, Bill Cosby, released on an appeal. So as we grapple with this very intense emotion and situation, so too are other people.
So the Bill Cosby example is really interesting, because what's similar to the Bill Cosby example in this example is that it's about technicalities. In this case, as I understand the judgment, and I must stress I've read it just once, and I'm not a lawyer, I need to read it again and perhaps a few more times, but there's technical issues around the behavior of the magistrate and the findings of the magistrate. Now that's fine. Well, it's not, but do you know what I mean? Let me put it to one side. What I'm trying to get to is that what we need to do as a society is say that if this man behaved immorally and unethically and took advantage, and I think the word that you used is important here, abused, used the word abuse, abused a woman, that man needs to first be, the behavior of the man needs to be assessed, and then he needs to be punished. That's why we have a court system. They assess and then they punish. And this whole system, I mean, I can think of so many cases. I mean, I've sat through one trial. You remember which trial that was in 2006. The whole system, frankly, I would argue, just doesn't work. I would suggest that our entire legal system on this doesn't work. Do we need to start again with something else? I don't know what.
I also don't know what, but when I read through the judgment, I was very taken by the fact that constantly the person referred to the fact that he thought that, he felt that. And so I think because there wasn't any consent, it was presumptive. And so I think that also needs to be clearly defined, because as I said at the beginning, consent to one act, whatever it was, and it was graphically described in the documents, is not consent to the next act. So he didn't ask for consent, he presumed it. She also didn't say stop in such a way that you could say this was the day, because being a virgin is not grounds for stopping. It's when I say no. And so it's very, very complicated.
There's a lot more to do here. I wonder if there will be an appeal. Might be valuable if there is. Mara Glennie, I really appreciate the time, founder of the Tears Foundation.